all the calls for a rules-based order, which we hear now since some years, are in a certain sense disingenuous. Thank you for the kind introduction. The topic of this session is global governance, and I followed with interest what the State Minister said about the importance of global governance and the cooperation of smaller states on the basis of sovereign equality in this effort to secure a global order of peace that is stable and, so to speak, sustainable. And let me just add or share a few reflections on the basis of our organization's cooperation with the United Nations now in the last 50 years. Unfortunately, this analysis will not be very edifying, but it has always been my view that one has to make an assessment of the facts sine ira et studio, and only if one does such, if one is aware and acknowledges the state of affairs and goes beyond the area of wishful thinking, can one admit with productive proposals for reform. As far as security is concerned, I would speak about international security in that framework of global governance. And let's just make one distinction between the terms of governance and government. Global governance does not mean global government. If we would have global government, there would be a world state which would absorb the sovereignties of all the existing member states into this huge structure. And I think this is, for the time being at least, in spite of Ernst Jünger's ideas, it is not something that is realistic or realizable. And what the United Nations provides is a kind of institutional framework for a global governance on the basis of a set of rules that should enable the organization to act efficiently and consistently. Unfortunately, in that regard, the United Nations has been the United Nations structure has been deficient since the very beginning for one simple reason. The system of security within the framework of international security, within the framework of the United Nations, is what is known in the meantime as a system of collective security, for which the main responsibility lies with the Security Council of the United Nations under Chapter Roman 7 of the Charter. So far, so good. The Security Council has, according to the Charter, the authority to take coercive measures in cases when member states violate the prohibition of the international use of force or when they threaten international peace and security. The problem is that there are provisions in the decision-making rules of that body, of the Security Council, that make the Council, and through it the entire organization, ineffective in the situations when it really counts. Just look at the ongoing war in Europe, Ukraine, Russia, or look at the ongoing war and violence in the Middle East or West Asia, however you would like to call it. The United Nations is a passive bystander, effectively, because the Security Council cannot adopt any resolution on the basis of Chapter 7, a resolution that would be binding and would have coercive and legal power unless the 5 permanent members of the Council agree. And that is not the case concerning the Middle East. That has also not been the case concerning the war in Ukraine. Whenever a permanent member or an ally of a permanent member is involved in a dispute, the Security Council is paralyzed. And we have to be aware of one basic fact, and that is most of the time overlooked because it's somehow hidden in the Charter of the United Nations. Of course, there is the so to speak, universal principle of law, nemo iudex in causa sua. No one is judge in their own case. Yeah, that is quite fair and understandable. And this applies to all the decisions of the Security Council under Chapter Roman 6, which is a chapter about resolutions that have not binding force, but that are legally recommendations. Recommendations for the peaceful settlement of disputes. What counts in the UN Charter is the authority under Chapter 7 concerning coercive measures. And for any decision under Chapter 7, this rule does not apply. But what applies is everyone, that means every member of the Security Council, is judge in their own case. And I mean, that is a recipe for anarchy, and that is the reason why we have seen all these wars of aggression during the Cold War, whether it's the Vietnam War or the first Afghanistan invasion in 1979, and so one could mention so many other illegal uses of force, and why we are seeing the violation of the prohibition of the use of force also since the end of the Cold War by a number of actors. And I would not, so to speak, exclude any one of the permanent members of the Security Council, whether it is the United States and, for instance, its invasion of Iraq in 2003, or Russia and its invasion of Ukraine more recently, or also, just one example, the total disregard, as far as the international rule of law is concerned, by the People's Republic of China of the legally binding decision of an arbitral tribunal concerning issues of maritime sovereignty in the South China Sea. And nothing will change in that regard as long as one does not introduce consistency into this system of norms. At the national level, of course, there is a constitutional everywhere. I would say where the rule of law prevails, there is a constitutional court. And in such a case where there is a conflict of norms, in this case, the norms a norm, for instance, on the prohibition of the use of force, and the other norm privileging certain member countries to prevent any decision on such a violation because they are not, because they have the right of veto and because they are not bound not to abstain in cases when they are themselves a party. At the national level, a constitutional court would change the law and would instruct the parliament to make the according changes and would invalidate the existing provisions. Internationally, that does not exist because as one calls it, the World Court, the Court of the United Nations, the International Court of Justice in The Hague, can only issue advisory opinions. It cannot take any binding decisions, even in cases of arbitration, if the Security Council of the United Nations is not assisting it in the implementation of its decision. And let me just add one more point, which is particularly striking. As far as this situation the implications of this situation are concerned for international criminal justice, which is one of the most spectacular aspects of nowadays international relations and of nowadays also thinking about international security. There is, as I would call it, a kind of unorganic linkage between the Charter of the United Nations, or between the United Nations organization and the International Criminal Court. Of course, legally, the International Criminal Court is an independent entity created by treaty, and it has nothing to do with the United Nations. It's not an affiliate organization of the United Nations. But according to the Rome Statute of the International Criminal Court, the Security Council has special rights concerning the jurisdiction of the International Criminal Court, the ICC. The prosecutor can only open an investigation if the prosecutor of the ICC, can only open an investigation in cases where crimes have been committed on the territory of a state party or by citizens of a state party. But in addition to that, and that is understandable, that according to the Vienna Convention on the Law of Treaties, states that have not signed the Rome Statute are not bound, are not subject to its provisions. But according to the Rome Statute, there is a special provision that authorizes the Security Council under Chapter 7 of the United Nations Charter, which is the chapter regulating coercive measures, to refer a situation where a crime may have occurred to the International Criminal Court. And in such a case, the court has jurisdiction whether a country is a state party or not. Of course, this decision is subject to the veto. That means never will any situation be referred to the International Criminal Court where that court has no jurisdiction sui generis if the interests of a permanent member are concerned. But the issue is going even further concerning security. Since Nuremberg, there is this, how should I say, public awareness or conviction that the paramount crime, paramount international crime, is the crime of the war of aggression. That is, in our legal thinking, that is, so to speak, the Nuremberg legacy. In the meantime, the International Criminal Court, the statute of the court has been amended, so the court now has also jurisdiction over the crime of aggression. But again, here we have an almost, I would say, situation that is really absurd. It's almost like the theater of the absurd. The Security Council may, just let the things be described in a very brief and concise manner, although they are rather complex. The prosecutor of the International Criminal Court may take up an issue concerning the crime of aggression and may declare that he will initiate an investigation. He can go ahead with it if the Security Council, so to speak, determines that there is the situation of aggression. However, if within 6 months no decision is forthcoming from the Security Council, he may go ahead on his own, motu proprio, so to speak. Again, that sounds quite good and reasonable, but the reality is that of the the reality is, again here, if the Security Council refers on its own a situation of aggression to the prosecutor of the International Criminal Court, the court has jurisdiction, and the court may go ahead. And again here, never will a case of aggression be referred to the International Criminal Court if one of the permanent members does not agree, or in particular if one of the permanent members is involved itself in that case of aggression. And the irony is that of the 5 permanent members of the Security Council, there are 2 that are also state parties of the Rome Statute. And there is a kind of loophole, but which they have not overlooked. Of course, they will never be subject to prosecution under a referral by the Security Council because they can veto such a decision, but they would be subject, their leaders or officers of those two member states who are state parties of the Rome Statute would be subject to prosecution in case that the prosecutor identifies a case of aggression and the Security Council does not come up with an approving decision within the period of 6 months. Anyhow, the prosecutor could go ahead. But he can only go ahead concerning aggression on the basis of the provisions for the amendment concerning aggression, because that has been inserted just a few years ago, this amendment, how the court exercises its authority. And only state parties of the court that have ratified also the amendment on aggression are subject to the jurisdiction. So for me, that's quite interesting and quite telling. The two European Union permanent members, the United Kingdom and France, in this particular case, preferred not to ratify the amendment on aggression. And that goes against all the lip service in Europe about the rule of law and international justice and so on, and how important it would be that all the member states of the United Nations join the International Criminal Court and so on. Concerning the most, how should I say, serious crime under the jurisdiction of the court, these two European Union countries, I would say against all what we say here in Europe and what they say in those countries about European values and commitment to fairness and equality among nations, stay away. And as long as this situation prevails, and as long as we do not address that within the United Nations framework, and through it also the wider framework of international relations, power ultimately, when it's getting really serious, trumps law, unless we address that issue and challenge the member states to do something about it, namely to amend the rules. Nothing can be achieved, and all the calls for a rules-based order, which we hear now since some years, are in a certain sense disingenuous if one is not really addressing, so to speak, the elephant in the room. So that's the point I wanted to make. Thank you.